Hey everybody, I hope you're not in the classroom right now, that you didn't go to class. I hope you're sitting somewhere comfortable where you can pay attention and take notes. Here's my plan for this video. I need to finish up our section on the U.S. judicial system that we were talking about in class yesterday. I need to talk about the pathway through the court system. Some of you already heard that. I got to that in at least one of my sections. If you already heard this portion at the beginning, you can fast forward or you can listen to it again and make sure you understand it well. I need to talk about the requirements that need to be met for you to file a lawsuit. I need to talk about when you're allowed to file a lawsuit in federal court. If you want to file in federal court, what are the things that allow you to do that? And then finally, I have some practice questions that I'll go over just to help you see how these principles apply in real life. So let's start with the pathway through the court system. What I'm getting at here is if you want to file a lawsuit, what court do you file in? And when do you get to go to the Supreme Court or the appellate court? What do these courts mean? And when do you go to each of them? The key point here is that everybody starts at the trial court level. There's 3 levels, and the trial court level is at the very bottom. So it doesn't matter if you're going to sue the President of the United States, it doesn't matter how important the defendant is, you have to start at the trial court level. It's at this level that you argue over what happened in the case, the facts of the case. So this is where you're going to, each side is going to tell their side of the story, and then the judge or the jury is going to decide, okay, who do we believe, what happened, and how does the law apply to those facts? If you lose at the trial court level, then you get to appeal if you want. You can say, I don't like that I lost, and I'm going to appeal that, and you get to move up to the next level, the appellate court level. Everyone gets one appeal if they don't like what happened at the trial court level, but it's important to know you can only appeal legal issues. The only thing you can argue at the appellate level is, I don't think that the trial court applied the law correctly. I think they got the law wrong. If you go up to the appellate court and say, I don't think the trial court understood the facts, or appreciated my evidence. Those are factual issues, not legal issues, and the appellate court will say, hey, sorry, look, the trial court decided the facts, and whatever they decide, those are the facts for every level. For the appellate court, for the Supreme Court, we just go with what the trial court decided about what happened. You can only appeal legal issues. Now, if you lose your appeal, you can then appeal again, and that would take you up to the top level, the Supreme Court. And again, you can only appeal legal issues. The Supreme Court is not going to get into fights about what happened and the facts. And the other thing is, unlike the appellate court level, the Supreme Court gets to choose whether or not to take your case. If you're appealing a legal issue to the appellate court, they have to hear your case. But the Supreme Court can look at it and say, sounds interesting, but no thanks. We're not going to take your case. And if they do that, if they don't take your case, then you're done. Whatever the appellate court said stands. If the Supreme Court does take your case, whatever they decide is it. You're done. You can't go anywhere higher than the Supreme Court. So that's the pathway. You have to start at the trial court level. You can't file your case immediately in the Supreme Court or the appellate court. And once you're done at the trial court level, if you don't like the result, you can't appeal directly to the Supreme Court. You have to go through each level. Okay, we talked about how the Supreme Court gets to choose what cases that they hear. When they do choose to hear a case, that comes up in one of 2 situations most of the time. The first is when there is a circuit split. And what I mean by that is when a federal appellate court, we call them U.S. circuits, U.S. circuit courts, if a U.S. circuit court decides an issue one way, and then a different U.S. circuit court somewhere else in the country decides the exact same issue but in a different way, then we have a circuit split. And the Supreme Court's going to look at that and say, man, we can't have federal courts deciding this same issue in a bunch of different ways. We need to go in and clear up this confusion and decide this issue once and for all. So an example of this is what we talked about last week. There was a U.S. Circuit Court that was deciding the issue of whether the word sex in Title VII, you can't discriminate based on sex, includes sexual orientation or identifying as transgender. And that U.S. Circuit Court decided that no, it does not include those things. You can discriminate based on sexual orientation or identification as transgender. That's what one U.S. Circuit Court decided. Another U.S. Circuit Court decided no, Title VII prohibits those things as well. So we had this circuit split, and the Supreme Court weighed in and said, all right, we're going to resolve this once and for all. And they decided that yes, Title VII does prohibit discrimination based on sexual orientation and identification as transgender. So the word sex in Title VII includes those things. So that's a circuit split. That's one time the Supreme Court will take a case. Another time is when somebody is challenging the constitutionality of a federal law. So here's an example of that from the news. There was a U.S. regulation, so a federal law, that said union leaders, you can go onto a farmer's property to talk to farm employees about unionization. Well, the farmers didn't like that, so they challenged this regulation and said, this regulation is unconstitutional. It violates the U.S. Constitution. Now, I'm not going to get into why they said that it violates the U.S. Constitution. It's a little bit complicated, but it's fascinating. And if you're interested in that, you should Google this headline and look this up. But in the end, the Supreme Court said, all right, this is a challenge to constitutionality. We're going to take this case. And this particular website that's reporting on this is called SCOTUS blog, SCOTUS. That's the abbreviation for Supreme Court of the United States. And they do a really good job. They report on everything the Supreme Court's doing, and it's really interesting stuff. It's a wormhole that you can spend a lot of time seeing what the Supreme Court is deciding, the big issues that they're deciding. One of the things that's cool is they show which justices voted that this was unconstitutional. And what do these 6 justices have in common? Well, these are our 6 conservative justices. And the conservative justices tend to be pro-employer, pro-business, and less pro-union. So it's not surprising that they voted that this regulation that is very pro-union was unconstitutional. Okay, let's do a couple practice questions just to drive these points home. All right, Ishan sues Governor Pritzker, claiming that the governor's mask mandate is unconstitutional. The case goes to trial and the governor wins. Immediately after the court announces its decision, Ishan exclaims, "I'm taking this straight to the Supreme Court and you'll be sorry." Will the Supreme Court hear Ishan's appeal? Is it A, yes, because everyone is entitled to at least one appeal? B, no, because the Supreme Court has discretion over the types of cases it hears and it's unlikely to accept this case? C, no, because he can't appeal from the trial court to the Supreme Court? Or D, yes, because the case involves the constitutionality of government action? Now, if you want to keep looking at that, pause it. I'm going to move on to the answer. So the answer is C, no, because he can't appeal from the trial court to the Supreme Court. It's true that everybody gets at least one appeal to the appellate court, but the Supreme Court gets to decide whatever cases they want. Okay, let's move on to the next one. So Emily gets sued for fraud in Illinois State Trial Court. Emily loses and gets slapped with a $150,000 judgment. But Emily's star witness didn't do a very good job of telling Emily's side of the story, so Emily doesn't think that the trial court really understood the facts. What can Emily do? Is it A, appeal to the Illinois State Appellate Court? B, appeal to Illinois Supreme Court? C, nothing, because appellate courts only review legal issues, not facts? Or D, file a new lawsuit in Illinois federal court? Okay, pause it if you want to look at this. The answer is C, nothing, because appellate courts only review legal issues, not facts. Everybody gets one appeal, but only of legal issues. You can't go up to the appellate court and say, hey, the trial court got the facts wrong. You can only argue that they got the law wrong. File a new lawsuit in Illinois federal court, that's option D. That's never going to be an option. You can't just say, I don't like what happened, I'm going to go try it in federal court. You can't jump from system to system. So we've talked about the pathway through the court system. Now we need to talk about the requirements that you have to meet in order to be able to bring a lawsuit. There are 4 main requirements that I want you to know, and the first one is standing. Standing is the main one that we talk about with these requirements, and it simply means that you're the right person to bring the lawsuit. You have standing if you were the person who was injured. It wasn't someone else, and it was an actual injury. It wasn't hypothetical. It isn't a future injury that you think is going to happen. It's concrete. I lost money, or I was physically injured. The second part of standing is that you were injured by the defendant. You have to have a reasonable claim that it was the defendant who injured you. And finally, a lawsuit has to help. So at the end of a lawsuit, you're either going to get damages. So the court will say, defendant, you have to pay the plaintiff this much money. Or the court may say, defendant, you have to stop doing something or start doing something. If none of those things are going to help, then you don't have standing. Now, the thing to realize here is that the court believes that money solves all kinds of things. So maybe the defendant caused you to lose an eye. Well, no amount of money is going to give you your eye back. But the court's going to say, well, how about $3 million? Will that make you feel better? And according to the court, yeah, that's going to help. So this idea of whether the lawsuit will help doesn't come up very often because the court treats it as though money helps most things. Okay? So the main thing with standing is, were you actually injured? Were you the person that was injured? And was it an actual injury? Not hypothetical, not future. Okay, that's standing. The second requirement that you have to meet is personal jurisdiction. So let's say I get sued in a court in California. Before the lawsuit can move forward, the California court has to determine whether it has personal jurisdiction over me, the defendant. What this means is they have to decide whether it's fair to make the defendant show up in court in California where the lawsuit was filed. If it would be unfair, then the court lacks personal jurisdiction. But if it would be fair for me to have to show up in a court in California, then the California court has jurisdiction over me. How do they determine whether personal jurisdiction exists? Well, they look at how much contact the defendant has with that state where the lawsuit was filed. So with California, they'll look at things like, do I live in California? If I'm a business, am I headquartered in California? Do I do business in California? Like, do I have a branch of my company there? Do I have contracts with people in California? Those are things that would give rise to personal jurisdiction. Another one is, did this lawsuit arise out of something that I did in California? So maybe I was just driving through California, but if I crashed there into someone and they sue me, I might not live there, I might not do business there, But because the lawsuit is arising out of an action that I took in California, then a California court probably has personal jurisdiction over me. So in order to meet this minimum contacts requirement, I have to have sufficient contact with the state. I either have to live there, or do business there, or have done something that gave rise to this lawsuit there in that state. The third requirement you have to meet in order to sue somebody in court is that the court has to have subject matter jurisdiction, which means they have to have jurisdiction over this type of case, this subject matter. This is really easy for a state court because they have general jurisdiction. They have jurisdiction over all types of cases. It's a little bit harder if you want to file in federal court. And we're going to talk about what will give a federal court subject matter jurisdiction over a case in just a minute. So put a bookmark there. And let's move on to this last requirement, which is the statute of limitations. Every state has a statute that says if you are going to bring a tort claim against someone in court, you have to bring it within 1 year of your injury, of being injured. If you're going to bring a contract claim against someone, you have to bring it within this many years of the breach of contract. So they set these time periods. For some kinds of claims, in some states it's 1 year. In some states it's 2 years. In some states it's 6 years. And if you don't bring your lawsuit within that amount of time, if you don't file your lawsuit, then you're kind of timed out. They'll say, sorry, you missed your window of opportunity to bring this lawsuit. So you have to check the statute of limitations and make sure that you're within that window. Those are the 4 requirements that you have to meet in order to sue in court. If you can pass those, then you can move forward with your lawsuit. Okay, before we talk about subject matter jurisdiction, I want to do a few practice questions just to talk about these 4 requirements and show you how they apply. And it's actually just one practice question, I think, but it hits on all 4 of them. So here's the question. Linhan works at Busey Bank in Champaign and is good friends with a coworker named Ralph, who is 65 years old. Busey fires Ralph, telling him that it's time for him to retire and make room for some younger employees. Linhan tells Ralph that this is a violation of the ADEA, but Ralph isn't going to do anything about it. He's not going to sue Busey Bank. So a few weeks after Ralph's firing, Linhan takes matters into her own hands and files a lawsuit against Busey in Champaign County Trial Court, alleging violations of the ADEA. Shortly after she files the suit, the court dismisses it. What is the most likely reason that they dismissed it? Is it that the ADEA is a federal statute, so the state court lacks subject matter jurisdiction? Is it that Linhan lacks standing to bring the lawsuit? Is it that the limitations period has likely expired on Linhan's lawsuit? That's how we talk about the statute of limitations. The limitations period has expired. Or is it that the court lacks personal jurisdiction over Busey Bank? So if you want to read that again, pause it, because I'm moving on to the answer. The answer is Linhan lacks standing to bring the lawsuit. Why? Because Linhan was not injured by Busey. She was not the person who was injured. It was Ralph. So Ralph has standing to bring the lawsuit, but Linhan does not. You can't bring a lawsuit on behalf of someone else's injury, in most cases. So what's wrong with this top one? It's true that the ADEA is a federal statute, but remember, state courts have general jurisdiction, so they get to hear all kinds of cases, including cases dealing with federal statutes. How about this one? The limitations period has likely expired on Linhan's lawsuit. Now, you didn't have reason to know this, but limitations periods are typically at least 1 year. Usually they're more than that, but they're at least 1 year. So where this was just a few weeks later, that's not going to be an issue. And then the last one, the court lacks personal jurisdiction over Busey Bank. Well, we have to look at, did Busey have minimum contacts with the state of Illinois, such that it would be fair for Busey to represent itself in court in Illinois. Well, Busey has minimum contacts with Illinois for 3 reasons. It's based here. You may not have known that, but Busey Bank is based here. It does business here. And the lawsuit arises from actions taken here, from this branch of Busey Bank in Champaign. So all 3 of those independently would give the state of Illinois, a court in Illinois, personal jurisdiction over Busey Bank. All right, so let's move on and talk about when a federal court would have subject matter jurisdiction over a case. So we can think about this as, we can imagine this as a federal court having a locked door. And the only way you can get your lawsuit into federal court is if you have one of 2 keys to that locked door. The first key is called diversity jurisdiction. If the parties to your lawsuit are from different states, so let's say one is from Illinois and one is from New York, then you have what's called diversity in your case, diversity of parties. If you have that, and if the amount of money that's at stake, the amount of damages that you're claiming, for example, is over $75,000, then you have diversity jurisdiction and you can take your case to federal court. So there's 2 requirements. The parties are from different states and at least $75,000 is at stake. That'll give you diversity jurisdiction and you can get into federal court. The other key is called federal question jurisdiction, and this means that the dispute in the case involves some federal law. It could be a federal statute, it could be a federal regulation, it could be the Constitution. If the case turns on or is based on one of these federal laws, then you can take it to federal court. You can still take it to state court if you want, but that will unlock the door to federal court and allow you to file in federal court. Now, in your in-class activity yesterday, I asked you to tell me, does this complaint, what does it say about jurisdiction, about personal jurisdiction, and about subject matter jurisdiction? And if you'd scrolled down in your complaint, you would have found a section called jurisdiction, and they'll say things like, this court has jurisdiction over this case, so we're talking about subject matter jurisdiction, under this federal statute. And it's either the diversity statute or the federal question jurisdiction statute. So that tells the court, this is a case that has diversity jurisdiction or federal question jurisdiction. Then it'll say, this court has personal jurisdiction over the defendant because, and oftentimes it'll explain what are the contacts that the defendant has with the state that gives this court personal jurisdiction over the defendant. Sometimes all they say is because the defendant had minimum contacts with the state. But sometimes they'll say, because they live here. Or because the subject matter of this lawsuit deals with an action that they took in this state. So they have to prove to the court that the court has subject matter jurisdiction and personal jurisdiction over the defendant. Okay, let's do a couple practice questions, and then we'll be done with the U.S. judicial system. So here's the first one. Eddie works at Ace Hardware. He makes several public posts to his social media accounts that paint the company in a very negative light. Ace finds out about the posts and fires Eddie. Eddie wants to sue the company because he believes his First Amendment rights have been violated. If Eddie and Ace are both residents of the same state, can he sue the company in federal court? Is it A, yes, because a federal court would have diversity jurisdiction? B, no, because a federal court would not have personal jurisdiction? C, no, because a federal court would not have subject matter jurisdiction? Or D, yes, because a federal court would have federal question jurisdiction? Pause it if you want to read it over again. Otherwise, here's the answer. D, yes, because a federal court would have federal question jurisdiction. What would the federal question here be? Well, It's based on this idea that First Amendment rights have been violated. The First Amendment is the U.S. Constitution. It's part of the U.S. Constitution. So we're dealing with a federal law, so they can take this to federal court. We don't know anything about diversity jurisdiction. We don't know what the amount at stake is or where the parties are from, so we can't really speak to that. But there would be federal question jurisdiction here. All right. Let's move on to the next one. Fat Sandwich Company thinks that its pickle supplier, Patel's Pickles, breached its contract with Fat Sandwich and thus owes Fat Sandwich $50,000. Patel's is based in Ohio. Fat Sandwich is located in Champaign. Can Fat Sandwich sue Patel's in Ohio federal court? Is it A, no, because the court lacks subject matter jurisdiction over the case? B, no, because an Ohio court lacks personal jurisdiction over Patel's. C, yes, because the court has federal question jurisdiction over the case. Or D, yes, because the court has diversity jurisdiction over the case. The answer? A, no, because the court lacks subject matter jurisdiction over the case. So the first question is there federal question jurisdiction? Is there some federal law that is at issue here? And there's not. This is just a breach of contract. We don't have a federal statute or regulation or anything like that. So next is there diversity jurisdiction? Well, is there diversity? Are the parties from different states? Yes. Patel's is from Ohio. Fat Sandwich is from Illinois. So we have diversity, but how much money is at stake? $50,000. That's less than the $75,000 threshold, so there isn't going to be diversity jurisdiction. So we don't have federal question, we don't have diversity. The federal court lacks subject matter jurisdiction over this case. Let's take a look at the others really quickly. So personal jurisdiction, well, Patel's, the defendant, is from Ohio. So yeah, an Ohio court is going to have personal jurisdiction over Patel's because they absolutely have minimum contacts with the state of Ohio. That's how one of these diversity questions is going to play out. The court has to look at, do I have subject matter jurisdiction? Do I have personal jurisdiction over the defendant? If so, okay, let's move forward. All right, that's it for U.S. judicial system. Now we're going to move on to tort liability.